I dealt with the reporting restrictions charge a few days ago, and I'm going to finish off with Tommy's case here. The second charge listed on the gov.uk site was publishing a video encouraging his followers to harass the defendants, creating a substantial risk that their rights would be seriously impeded. Fleshed out thuswise in the judgment. Breach of the strict liability rule of the Attorney General's case is that the respondent, Tommy, committed contempt by being responsible for a publication which created a substantial risk that the course of justice in the Akhtar trial and the related trials would be seriously impeded by reason of its impact on the defendants. And they go on to expand on that in paragraph 68 there in gobbledygook, for which I've done an English translation. 1. The defendants might either be, or they might think they might be, harassed on the way to court by Tommy's supporters on account of the livestream, and in which case the police might then have to assist the defendant's passage to court, and the defendants might abscond having seen the video. And this bit is where the government directly lies. In support of these arguments, the Attorney General relies in particular on the passage in the video that we have already quoted, which is characterised as an incitement to the respondents' supporters to harass the defendants. Because of its importance to this part of the case, we repeat the passage, and the judges quote the government's edited, that is edited, submission of Tommy saying, you want to harass somebody's family, you see that man who was getting aggressive as he walked into court, blah blah blah, harass him, find him, blah blah blah, you want to stick pictures online and call people and slander people, how about you do it about them? I'll come back to that in a bit. After that they list the various other things he said that they claim as insightful, like got your prison bag, is there any guilt, etc. You might notice that they leave out the relatively innocuous how do you feel about the verdicts question he asked, but they do include dirty bastards in it and should fucking hang him. You can see that at the top there just before paragraph 71. The slight difference being he didn't say that, other people did. But that didn't stop them including them in the report remarks he didn't say, while leaving out his own exculpatory remarks. His barrister took a good shot at getting the whole thing thrown out. Mr. Furlong submits that, however it may be framed, in substance and reality, the Attorney General's case before us is one of prejudice to the course of justice, and thus that strict liability contempt by publication can only be made out means upheld, found guilty, on proof of conduct that gives rise to a seriously arguable ground of appeal. I am at hand with another translation. The government set a high threshold of seriously impeding justice, and since the measure of such would be conduct that could lead to appeal, and therefore seriously impede justice because they might get off, and because Tommy's conduct didn't meet that threshold because there was an appeal and it was rejected, well then, throw the whole thing out. Basically, what he did wasn't bad enough. Gee, I wonder what the judges thought about that. We do not accept this argument. Wow, what a shock. So, back to the famous passage. You know how the government selectively quoted his words to give them a different meaning? All that stuff there about him apparently encouraging his supporters to attack the defendants, which is laughably false when you don't leave out bits. So that's the text the government selectively quoted, and as if by magic, there's the bit they left out. You know this lad who runs Generation Identity? I found out that the media has been harassing his family, you want to harass somebody's family, etc, etc, etc. No context, context. No context, context. They do report his obvious explanation. The respondent, Tommy, says his words were not intended to encourage his followers to harass the defendants, but rather to denounce the media for their behaviour towards him and others. In our judgment, those words and the manner of their delivery were an encouragement to others to harass a defendant by finding him, knocking on his door, following him and watching him, and this gave rise to a real risk that the course of justice would be seriously impeded. Well yes, of course they give that impression if you leave out the key context as they did. There again, the government submitted those edited words and the court does not reinsert the key context anywhere else in the section. Nowhere. They just report on his explanation without reporting the actual words he said. There again, leaving it looking like he didn't actually say what he said about the media and giving the impression that he's making it up after the event. Which they know full well, because they've seen it as well as anybody else. We are sure that what the respondent said in this passage will have been understood by a substantial number of viewers as an incitement to engage in harassment of the defendants. This is the lengths they went through to force through a charge which couldn't go through on the basis of what was actually said. You know how you get a camel to pass through the eye of a needle? You cut away all the stuff that won't fit and then it just goes through easily. That's how they made this charge go through. They left out stuff which was entirely relevant. The risk of absconding bit towards the end is in paragraph 68 there, which I've simplified as the defendants might abscond having seen the video. That comes down to judge's opinion, and it's hard to skewer it quite as easily as the reporting restrictions one and the incitement to vigilantism. So right at the end there, furthermore, there was plainly a real risk that the defendants awaiting jury verdicts would see themselves as at risk, feel intimidated, and that this would have a significant adverse impact on their ability to participate in the closing stages of the trial. What can you say? Send a police car to bring them in then. There was no active participation on their part required at this stage, so it's arguably somewhat irrelevant, even if they did feel a little bit intimidated. If it was a key stage, fair enough, but this absolutely was not. But at the end of the day, this comes down to the judge's opinion. It's not worth wasting any time on, and at the end of the day, they've already hung themselves out to dry. For these reasons, we find the Attorney General's second ground to be made out. These reasons including literally pretending that key statements didn't exist, both in the government charge and in the judgment. Those words at the top are listed nowhere in the judgment. Stick me in Belmarsh if you can find them. You will not. So, pretty much done here, because charge 3, illegally photographing and intimidating defendants as they entered court, is to me so similar to publishing a video encouraging his followers to harass the defendants, blah blah blah, as to be another inevitable variant of upsetting Muslims. This bit will do. We find that the respondent's conduct did give rise to a real risk that the defendants he confronted would arrive at court in an upset and agitated state, unsuitable for participation in the serious proceedings in which they were due to take part. Proceedings they had no active part to play in, other than standing up and saying, "F you, my lad, for the 20-year sentences and kebabs are on me." We agree with the submissions made on behalf of the Attorney General. Of course you do. This thing was decided before it was ever started, so here, in place of anything else, I'm just going to repeat a bit of whataboutery I've done before, but which bears looking at again. This didn't give rise to anxiety.
Muslim pedo off our street!
Muslim pedo off our street! Go show your face!
Go on, cowards! Go on, you
Scum! Scum! Covering your faces up for!
And this didn't give rise to anxiety. What about the anxiety caused here?
Tommy Robinson, are you finally going to face justice for essentially collapsing this trial? No, are you finally face justice for these charges?
That doesn't serve any purpose other than highlighting at a human level the obviously crashing double standard in all of this. The judge would say, well, that was that and this is this, and dismiss it on that basis. The first two videos are obviously at a way higher emotional level, and everything else is the same. Same defendant, same court, same everything. The judge had no problem, obviously, because there was no problem with what they were doing, and the police were at hand if the judge had decided there was a need to send them in to sort something out. The judge had no problem with all that stuff on a way higher emotional level. And the third one, aggressively confronting the defendant. Have you signed my petition, by the way? It's got over 10,000 signatures to date. BBC's Lucy Manning is doing the same and worse than he did, aggressively confronting and filming him as he entered court with loaded questions, clearly hinting at his guilt. Signed yet? Link is in the description as per usual. All that just goes to the crashing double standards. What is practically relevant, in summary, is reporting restrictions in the criminal courts. Trial judges have no power under Section 4.2 to postpone publication of any other reports in relation to matters not admitted into evidence or prejudicial comment in relation to the proceedings. Likewise, courts have no power under Section 4.2 to prevent publication of material that is already in the public domain, which, as we know, their unimpeachable lordships dismissed as, "We believe the point the Judicial College was striving to make was that a Section 4.2 order cannot prevent the publication of information in the public domain which is not or does not purport to be a report of the relevant proceedings." Strike 1 Milad. The guidelines are clear, Milad, and your caveat, which is not or does not purport to be a report of the relevant proceedings, is not part of them. That is a reach too far. Strike 2 as above. The respondent says his words were not intended to encourage his followers to harass the defendants, but rather to denounce the media for their behaviour towards him and others. In our judgment, those words and the manner of their delivery were an encouragement to others to harass the defendant by finding him, knocking on his door, following him and watching him, and this gave rise to a real risk that the course of justice would be seriously impeded. Well, yes, they are, if you leave out clearly relevant context, pretend it's not there, both government and the court, the Old Bailey no less. But, alas, ah me, and well-a-day, it is there. Two clear grounds, in my non-expert opinion, where the findings could be questioned. One more thing. Carl Benjamin, Sargon of Akkad, and Lucy Brown, Tommy's ex-camera girl, two people I entirely respect. Both of them, Carl in a video he did last year after the appeal, bit late then Carl, and Lucy in her recent thoughtful, intelligent, articulate video expressing concerns of various kinds, all of which I endorse, and all of which triggered the inevitable bunch of bare-chested, beer-swilling Robinson rednecks, Hillary Clinton's basket of deplorables, into a downvote frenzy similar to the one I experienced after telling my own corner of the internet that I endorsed the judge's rejection of Tommy's Cambridgeshire case. Free speech, free speech, free speech, and they never get the irony. Anyway, both of them have said, both Carl and Lucy have said, Carl in his video last August after Tommy's release on appeal, and Lucy in her recent video, which reminded me of Carl's video, they both said, we don't want to talk about this because we have no legal expertise. It's funny, people will read Shakespeare and then be afraid to look at a document which at the end of the day is just argument presented in flowery language. That's all it is. Argument, the occasional arcane reference to a statute or a case or something which you can probably look up online anyway. But people say, oh no, we can't go anywhere near it because it's legal stuff and we have no qualifications on that. And on that basis, they get a free pass. The judges get a free pass because they issue judgments and nobody looks at them. And they get away stock-free, in effect. So to that end, to the end of facilitating the thing, I've made an index page for the judgment which hopefully renders the whole thing a bit less daunting, so that those of you who have so far been put off going through the thing can use that plan there as a means of biting the bullet and taking a look for yourself. It should help in navigating the whole thing. If nothing else, to see the full context of everything I've highlighted. This video might get, if I'm lucky, 10,000 views, but at the end of the day it's only one video, and if people upload comment to their own platforms, well, it spreads out and more exposure is only good exposure. Obviously it requires the ability to read and to process information, but I've kept everything fairly straightforward and I've made a point of drilling home as clearly as I can the key points. So what's not to love? Anyway, that's it. Thanks very much.